Hello and welcome to our presentation on investment advisor registration for fund managers in 2012. My name is Bart Mallon from Cole Freeman and Mallon. We are a boutique investment management law firm, and my practice is focused on hedge fund managers and the regulatory and compliance issues they face at both the federal and state level. The goal of this presentation is to provide you with an overview of the major issues that fund managers face with respect to registration after the Dodd-Frank Act. The presentation is designed to be high level. We will touch on the important topics and leave more of the details for the articles posted on the website. We have a URL, hedgefundlawblog.com/IA registration 2012. And you can find more information on the topics involved in this presentation at that web page. We have the goal of trying to get through this in about 30 minutes or so we'll begin now. We will start with an overview of the laws, go into who has to register, discuss some of the registration exemptions, the registration deadlines, the Form ADV and the Form ADV Part 2, which the managers will be submitting to the SEC. We'll provide an overview of the registration timeline, the registration costs, and then we'll get into compliance, what needs to happen at the beginning, and post-registration compliance matters. And we will finish up with a discussion of some other issues that managers should be aware of. To start off with an overview of the laws, we basically have the Investment Advisors Act of 1940, which is the federal act that requires registration of investment advisors. In general, this means that this applies to those managers who are providing investment advice with respect to securities for compensation. So all of the laws that are in the Investment Advisors Act apply to investment advisors. Some of those laws include anti-fraud provisions, limits on performance-based compensation. There are also provisions that coordinate the federal and state regulation of investment advisors. So the Investment Advisors Act applies to federally registered advisors. The state securities laws apply to state registered investment advisors. The laws at the state level in general will mimic the laws at the federal level. Each state is going to have a little bit different laws, but ultimately they're based on the same Model Securities Act, which is based on the Investment Advisors Act. The regulatory agencies which will be overseeing the implementation of the laws include the SEC and the State Securities Commission. Obviously, the SEC is going to be enforcing the federal laws, that is the Investment Advisors Act. The State Securities Commission is going to be enforcing the state laws, and together both groups generally are going to have anti-fraud jurisdiction so that they can oversee certain anti-fraud activities. Now, there are new laws and regulations that have come into effect after the Dodd-Frank Act. The most important for our purposes today is the registration requirement for private fund managers. And by private fund managers, basically those groups who are providing investment advice to Section 3C1 and Section 3C7 hedge funds. This is also going to include private equity fund managers who previously have not been lumped into this registration category with hedge fund managers. Another important item is this regulatory assets under management definition. This is a new definition and important for managers because based on the regulatory assets under management, it will dictate how a manager is registered, whether with the SEC or the State Securities Commission. This definition includes all assets on a gross basis. So this means if a manager is using leverage, you're going to need to include those leverage assets. It also includes uncalled capital commitments. So this will be especially important for those private equity fund managers. Now, who has to register? We've got SEC and state jurisdiction, an overview of the registration requirements, and then there's a special group of managers called exempt reporting advisors. To start off with jurisdiction, we've got the SEC and state jurisdiction. Previously, there was this $25 million threshold where managers over $25 million were subject to SEC jurisdiction, and below $25 million, they were subject to state jurisdiction. That line has now moved to $100 million. So in general, managers over $100 million will be subject to SEC jurisdiction, and below $100 million will be subject to state jurisdiction. In addition, managers in New York with between 25 and 100 million will be subject to SEC jurisdiction, along with all managers who are located in Wyoming. On the state side, in general, managers with less than 100 million are going to be subject to state registration. And then there is a $10 million buffer each way. The buffer is $10 million each way, such that a manager will not be required to register with the SEC until their assets under management reaches 110 million. And likewise, an SEC manager would not need to deregister or switch to state registration until that manager had less than 90 million of assets under management. And the reason for that, obviously, is the assets are going to be continuously increasing in value and decreasing in value, and so that buffer zone is there for managers so that they don't need to go back and forth between SEC and state jurisdiction. Now, for the specific registration requirements, we'll start with managers with less than 100 million. In general, those managers are going to be subject to state registration unless they're subject to an exemption by that state's laws. And we're going to be talking about state law exemptions a little bit later in this presentation as well. For managers with more than 100 million who have separately managed account clients, they're going to be subject to SEC registration. For managers with between 100 and 150 million of assets with only hedge fund clients, they are not going to be subject to SEC registration. However, they are going to be deemed to be exempt reporting advisors. For managers with more than 150 million, they're going to be subject to SEC registration. Again, for managers with between 25 and 100 million located in New York, they will be subject to SEC registration unless an SEC exemption applies. And again, for managers located in Wyoming, they are also going to be subject to SEC registration unless an SEC exemption applies. Now, for exempted reporting advisors, we have venture capital fund managers, private fund managers that we discussed with the 100 to 150 million. Both of these groups are exempt reporting advisors, and then that means that they are subjected to this registration light regime. Under this regime, they are not specifically registered with the SEC. However, they do have to submit certain periodic informational filings to the SEC, and we'll get into those a little bit later on in this presentation.